and welcome to episode 6 of The Legal Scoop, our monthly webinar series where we discuss recent notable wins here at LOMAD. My name is Brendan Shannon. I'm an associate attorney with the law school Melissa Day. I'm joined today by my colleague Maria Lua, who's going to talk about a notable win that she had involving the recent Padland decision. Say hello, Maria.
Hi, good morning. It's nice to be here.
Yeah, we're glad to have you. This is your first appearance, correct?
Yes.
Perfect. So I understand that your case was a repetitive use claim that, like I said, involved the recent decision from the third department in Padland VPAL Environmental. So why don't you just give me a little background, some of the facts, and we'll get into what happened.
Sure. This case involved a claimant who worked as an auto technician for 30 years. He filed a repetitive use low back injury claim, and he submitted reports from his doctor finding causal relationship and diagnosing him with low back injury. We got an IME. The IME also found causal relationship and made references to claimant's job duties, but also in a vague manner. So we waived the cross-examination of the treating physician because we were already of the position that those reports, even our AMI reports, did not meet the standard under Padland and the other cases regarding the standard of proof or evidence that's going to have the claim established for repetitive use injury.
Okay, so that's actually really interesting. So what you're saying is that we had a case here, repetitive use claim, for someone who had held the same job for 30 years, where his treating doctor said that he developed this low back injury as a result of repetitive activities at this job that he's held for 30 years, and that our IME found the same thing.
Yes.
Okay. And we waived cross-examination of the treating doctor.
We did.
Okay, so now could you just explain why did we waive cross-examination of the treating doctor?
Because at that point, we were already of the position that when you look at the reports, they're definitely not going to meet the standards under Padland, which is that the doctor has to offer something more than just a generic reference to the claimant's work activities, that he has to display an adequate familiarity with the claimant's work duties, such as the frequency by which the claimant performed those duties or the tools that he used. And based on what we saw on the reports and even on the IME reports, it was clear that it's not gonna fly.
Okay, perfect. So I want to talk about Padland a little bit, and that's a case from 2022, third department, and it's been a really helpful case for employers and carriers in that it makes it a little bit, it makes it so that someone who's claiming repetitive use or an occupational disease needs to, make sure that their doctor goes into enough detail about how their job duties actually cause the injury or injuries being alleged. So here, and I guess a way of like giving an example would be that usually under Padland, what you're looking for is very specific details. Talking about duration and, like you said, tools being used. But then there's another, element to the consideration under Padland, which is here's the highly specific things, duration, and these things are accurate. If you're contrary to claim, you might take testimony and determine that actually they might have said that these were these specific things that the claimant did, but we have a supervisor who can testify otherwise. But then the second element is that you have to say that, okay, these were the job duties and these job duties caused X injury, and here's why. And a lot of doctors don't do that. And it sounds like here, the treating doctor gave probably a fairly vague description, basically saying, let me guess, claimant worked as a auto technician for 30 years, which caused him to develop a back injury. Is that about it? About right?
Something like he was engaged in repetitive lifting and crouching all day.
There you go. Yeah, that's very common. Yeah. Okay. So why don't you tell me about what happened at the hearing? So as a refresher for everyone, because we've kind of been talking about the law for a little bit, this is a case where both our IME found causal relationship and the treating doctor. Usually someone would consider that to be a lost cause.
I know. So at the hearing we attended, I think everybody was just ready to have the claim established and just to get a date of disablement set. because we have an IME, like you said, a minor cultural relationship. The claimant testified on his job duties and the fact that he mentioned those job duties to the treating providers, and then we also have the treating providers opining cultural relationship. So it looks like a lost cause, but still we argued for disallowance of the back claim, and our main weapon was case law.
Wow.
Yes.
Okay, so that's what happened at the hearing. What was the reaction of the judge?
She said that we made a pretty long summation, and the judge said you can just mention all of that during the appeal, and then established a claim for a low back injury.
That's fantastic. Also, if anyone can hear my dog crying and barking in the background, I would say that that's something that's only common with working from home. But at LOMAD, we usually have 1 or 2 dogs walking around, so it's kind of part of the course.
Don't worry about the decision of the law judge.
Yeah, exactly. So that's very funny that the judge reacted like that. So then we went to an appeal. Why don't you tell me about your arguments on appeal? I think we pretty much already have an idea of that, and then the result.
Yeah, the appeal was just basically a repetition of everything that we said during submissions. We said that there's insufficient medical evidence on file, which would establish the causal link between the job duties of the claimant and his work injury. We stated that the doctor, even the IME doctor, did not have adequate familiarity, which rises to the level of specificity required under Padland, Bonnet, and Sanchez, and all the other appellate division cases we just recently discussed. So the board panel agreed with us. It reversed the decision of the law judge and disallowed the claim.
Wow. Well, that's fantastic, and I think it's a really great example of a situation where when some cases the facts are good, and in that situation you would argue the facts, and sometimes the law is good, which is this case here, and in those situations you argue the law. I think it's also a good example of something that we take very seriously here at LOMAD, which is that just because a case might seem like a lost cause, if you look a little closer, do some research, you might sometimes find that we actually have a viable argument, and sometimes we succeed with those viable arguments. So congratulations, Maria. That's an outstanding win. And I think it's important for everyone, adjusters, employers watching, to be aware of the Padland decision and the implications that it can have with occupational disease and repetitive use claims. It's only been further supported by additional cases all coming out in 2022, and we suspect that will continue in 2023. So, Maria, again, thanks for joining me today to talk about this really wonderful win, and congratulations.
Thank you. Thanks for having me here.